The chair recognizes the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Attorney General. I want to cover a couple of areas, but I want to start with something that's very important to me. I think it's important to all people in this country of good conscience, irrespective of their political ideation, and that is the independence of the Department of Justice. And in my judgment, 2016 and 2017 have been challenging years for the Department of Justice. The decision to charge someone carries with it multiple layers of review. There's a grand jury, there's a petit jury, there's a trial judge, there are post-trial motions, there's appellate courts, there are courts of habeas corpus, and then there's the media, and then there's Congress. But the decision not to charge someone does not carry with it the same corresponding layers of review. But in some instances, it's every bit as important to understand why law enforcement did not do something and why prosecutors did not do something. I'm not interested in relitigating the FBI's decision not to charge Secretary Clinton. That decision's been made, it's been explained, and I'm not interested in relitigating it. I am, however, interested in reviewing 2016 and 2017 with respect to the Department of Justice. And Mr. Attorney General, there was a time when my colleagues on the other side of the aisle were interested in having some of these questions answered as well. It wasn't a year ago that some of my Democrat friends wanted Jim Comey investigated and prosecuted for a Hatch Act violation. That was 12 months ago. And it was absurd then, and it's absurd now. But what's not absurd is when my Democrat colleagues ask, why did you decide to publicize one investigation but not another? Why did you decide to appropriate a decision away from the Justice Department, which is very unusual for the head of the FBI to serve as both the investigator and the decision maker? Just like Republicans wanted to know, Mr. Comey, did you reach your conclusions before the end of the investigation? Did you make decisions whether to charge or not to charge before you interviewed all of the witnesses? These are questions that, to me, go to the core of whether or not the department can be respected, separate and aside from politics. I mean, I guess that certain departments are just inherently political, but the Department of Justice should not be. And so I tell you that up front, that Chairman Goodlatte and I are going to be looking into the decisions made in 2016 and 2017. And I think I can speak for him, and I know I can speak for myself. My motivation is a love for that department and a love for the concept of blind justice that doesn't care whether it's an even-numbered year or an odd-numbered year. And to the extent that there were decisions made, including the decision to write a public letter in October of last year and follow that up with another public letter in November, those are legitimate questions, and I hope that the department will cooperate both with respect to making witnesses available, but also with respect to documents so Congress can better understand the decisions that were made and not made and restore some modicum of trust that all people, whether they agreed with the decisions or not, at least understand why they were made. Now, Mr. Conyers asked you whether or not it was appropriate for the president
Could I respond just briefly to that?
Yes, sir.
You're familiar with the Inspector General.
I'm meeting with him.
And they make public their investigations. And several of the matters that involve the FBI are in the full and intense review by the Inspector General, and perhaps they can, under their rules of disclosure, perhaps you could inquire more about how that's ongoing. But I'm not able to give the details to you at this time. That's a serious matter. It's in my response to the chairman of yesterday.
Well, I didn't intend to ask you to respond to it because you're right. Mr. Horowitz is looking into it. In fact, I'm meeting with Mr. Horowitz this afternoon, not in that capacity, but in another. And you're right. At some point, he's going to let Congress know what he found, but that does not absolve us of our responsibility to also look into it. Mr. Conyers asked you whether or not it was appropriate for the president to weigh in an ongoing investigation. And, of course, the answer to that is no. It is not appropriate. It's not appropriate in 2017. It wasn't appropriate when President Obama did it in the IRS targeting scandal. It wasn't appropriate when President Obama did it in the ongoing investigation into Hillary Clinton's server. It is never appropriate for a president to tell a Department of Justice what outcome it should reach. I just wish my friends on the other side had the same outrage when President Obama did it as they do now. I mean, I guess that's what this will be my last question to you. You're nominated by a president. You're approved by a Senate, but yet you work for a virtue. You work for a blindfolded woman holding a set of scales, and that is what makes our culture different. How do you restore people's trust, Republicans and Democrats, confidence in a Department of Justice when it seems like different rules apply depending on who's in power?
The time of the gentleman has expired. The Attorney General will be permitted to answer.
Well, it's a good question and an important question. We intend to do our work according to the established principles of the Department of Justice. We will not be infected by politics or bias. We will make only decisions we believe are right and just, and we're not going to use the department to unlawfully advance a political agenda. We're going to enforce the laws of this country effectively as Congress has passed them, and I am determined that when the years go by, that people will say this Department of Justice did not crumble. It stayed firm and true to the great principles that I was taught in the 15 years I served in the Department of Justice, 2.5 as an assistant, 12 as United States Attorney, and looking up to the Attorney General is somehow so far removed from me that it was beyond recognition. But now I'm in that position. I think I understand the gravity of it. I think I understand the importance of responding to your question, and we'll do our best.
Yes, sir. Thank you.
The chair recognizes the gentleman from Louisiana, Mr. Richmond, for 5 minutes.
Mr. General, I have the honor of serving as chair of the Congressional Black Caucus. You were not there, but I'm sure you are aware, and if you're not aware, I'm telling on myself, that I testified against your nomination. And I did so because I was afraid that we would go back to a time where discrimination was rampant and that diversity was not appreciated and that the right to vote for minorities and African Americans would be further, more obstacles would be set up. And I listened to your opening statement and I listened to your remarks since then, and you talked about voter ID. The VC case, which in Texas ruled that Texas voter identification law had discriminatory portions against African Americans. The district court ruled that way, the appellate court affirmed that ruling, and then you withdrew from the case after 2 courts ruled that it was discriminatory. How does that mesh, and then argued on the side of Texas, how does that mesh with the right to make sure that African Americans had unfettered access to the voting polls?
Congressman, the way that happened was that Texas had passed a voter ID law that the courts did not approve but struck down. Election was coming up, I believe, and the court approved a voter ID procedure that they approved for that election, and the Texas legislature then repealed its previous law that had been found to be unconstitutional or improper and passed the one that the court had approved. So we felt that the voter ID law has been approved. A proper voter ID law is constitutional, and we believe that one is constitutional, and that's why the position was changed.
And also in judging Department of Justice, in terms of nominating judges to the bench, our information tells us that out of all the judges that have been nominated, I think 91% have been white males. Does that foster diversity?
I'm not aware of the numbers, but you should look for quality candidates, and I think diversity is a matter that has significance.
Well, the National Bar Association could recommend and has recommended a number of African American and other minority attorneys who are qualified. So let me just ask you, and if you don't know the answer to these, just let me know that you'll get me the information. But how many African Americans do you have on your senior staff?
I do not have a senior staff member at this time that's an African American.
Out of all
I would note in Alabama, I participated in recommending an African American judge, and I've had judges before. And
we're talking about this administration, though. Of all of the U.S. attorneys that have been nominated or confirmed, how many have been African American?
One in Alabama that I've recommended that I knew.
And I believe
he's been confirmed.
I believe it's only that one. Out of all of the special agents in charge of FBI bureaus around the country, how many are African American?
I do not know.
Would you get that for me? And here's the gist of what I'm saying. For a lot of people who objectively look from the back, like I do and many people where I live, the question is whether we're going towards inclusion and diversity or whether we're going back. So I applaud the president for his approach to the opioid epidemic, which everyone in this room is concerned about. We're losing over 100 people a day. But your decision to reverse Eric Holder's Smart on Crime initiative goes back to the crack, tough on crime, and I think you specifically said that you want the U.S. attorneys to charge and pursue the most serious, readily provable offenses and sentences. But with opioids, we're treating it as a mental health crisis. And the question becomes from the outside looking in, is it because of who the opioid crisis is affecting as opposed to crack? Our answer to crack cocaine was mandatory minimum sentences. So the question is, how does an outside observer reconcile how we treated crack, and which led to mass incarceration, which now with an epidemic we're losing thousands and thousands of people a year, and we're treating it with hugs and kisses and treatment as opposed to tough on crime, lock them up. How do I reconcile that and not conclude that the only difference is race and income?
Well, I would say that the federal court focuses on serious offenders, not users. We talk about international drug cartels. We talk about distribution networks, serious gangs, MS-13. We focus aggressively on that. But the PSN, the new reinvigorated crime problem, focuses more, and I've been convinced of this, on the leading criminals in a neighborhood. And the federal government will not seek mass incarceration so much as we will be focusing on identifying the people who really are the driving force, maybe sucking other young people into crime that would never have been brought in there if they hadn't had this leadership drive. It's worked in New York, it's worked in other agencies, and I think it will work here. And Congressman, I would note that the average federal sentence in the last 3 or 4 years has dropped 19%, and the federal prison population is down 14%, while we are beginning to see a spike in homicides, the likes of which we hadn't seen since the 1960s.
Time of the gentleman has expired. The chair recognizes